Clock in, clock in. Black guy just walked in.
Yeah. He already dead, there ain't no need to check his vitals, bitch. He already dead, there ain't no need to check his vitals. Yeah, crunch time, yeah, nigga, it's lunch time. Let go, crunch time, yeah, nigga, it's lunch time. Yeah, crunch time, yeah, nigga, it's lunch time. Let go, crunch time, yeah, nigga, it's lunch time. He dead.
Team Black gotta stand up, man. Yeah. After all the chaos in the courtroom, man, I've been looking like it's been so many objections and, oh, get out the courtroom real quick. We need recess. We need a break, man. Brain is just everywhere. It's just so much going on in this case. One moment you feel like stayed up one, the next moment you be like, damn, Dolores is up one. But one thing I can say, Melly's lawyer is handling the situation very well. I ain't gonna lie, bro. He just keeps shutting everything state throw down, like completely down. You feel what I'm saying? If reasonable doubt was a person, it would be the state right now. But there's no telling what they got up their sleeve, because you know it's still a little early. I wouldn't be surprised if state come out of nowhere, bro, with a crazy witness or something. You feel what I'm saying? But let's get into this video of Melly's lawyer seeking a mistrial, cause bro, it's too much going on in here, bro. It's a little bit too hot out here. Milk, judge, can we get milk? Let's find out.
Sure as I could predict that Tuesday comes after Monday,
I hope so.
I made sure to stay up till 2 o'clock last night to get these cases, to alert the court to what was the state's obvious intention. To put a witness on there for the purpose of introducing out-of-court statements that are otherwise inadmissible.
Talk game.
Instead of at least admitting that that was what the state intended to do, it advanced a ruse pretext that they were seeking to do so under 8035. It turns out that 8035, given the witness's testimony, could not be employed. And so the state then went back to plan one, the original one all along, of the state reading evidence from written documents of out-of-court statements, including police reports, statements on Instagram, arguments being had.
That's all they got.
Into the record. Through the state's own mouth, knowing very well that it was improper, that the court had ruled that it should not and could not be done, and it does not somehow become relevant because they declare hostility, which they knew about from the inception. The state made a representation to this court that it was a complete surprise. That's not a credible statement. I think it is incumbent upon this court to discern the veracity of that contention. There was a witness there, happened to be Ms. Holmes's lawyer. He's present. The state essentially tried to circumvent the rules, circumvent the order of this court, and testify to this jury about documents and information that it wanted to put before the jury, which it found no permissible way to do. The court warned the state, I don't want you trying to go through the back door, but you can't get through the front door, and they launched immediately into that pursuit. The jury sat there while the state made implication after implication, introduced admissible evidence after admissible evidence to the substantial prejudice of this defendant. And so not only did they do it after we raised the issue, they did it after the court ruled against the state and admonished the state not to do just that. And they launched into that pursuit. Mr. Devins has been prejudiced. This jury sat there and watched this fiasco unfold with at least 10, maybe 15 sidebars after every 2 questions.
For sure.
With the implications that were being, all predicated on the implications and the inadmissible testimony that Ms. Bradley herself read into and spoke into the record. And for that reason,
just like get to it.
That it was deliberate.
Yeah, we know you want a mistrial.
It's highly prejudicial. This jury has been tainted, and we move for a mistrial. Oh, there's one more thing. If you don't mind, I'll have Mr. Alistine articulate what that might be.
This is your motion for mistrial, Mr. Addison?
Yes, it's our motion for mistrial.
This is the second one. All right, go ahead.
Well, it's second one. Judge, in my entire career, I've never heard the state imply with no evidence whatsoever that the defense team would take care of this witness. And even though the court gave that instruction and told them to ignore it, that question, the defense team would take care of you if you answered like this, is so improper. Not only does it taint our client on the other questions, but it taints everybody at this table.
Mm-hmm.
And
yeah, this is kind of wild. Although I don't think they gonna get the mistrial. And if you can see right here, the lawyer is a little bit pissed because he know that state is literally doing it on purpose, bro. They knew that the judge say, do not go in there and talk about her getting bribed or whatever the case. Don't bring it up. Still brought it up for the jurors to hear it. Now it becomes damn, she got paid to do it. You feel what I'm saying? So now they seeking for a mistrial. Look, he over here pissed like she know what she doing. She just wanted to see it so they could hear it. She knew we would go object and she want to do that. You did what I'm saying? Because now it's looking like she got paid a lot, man.
Judge, Your Honor's instruction to ignore it. It's pretty hard to ignore something like that when their entire questioning for the last 30, 40 minutes have been so improper and the court told them not to do it. And they proceeded and proceeded and proceeded. We're moving for a mistrial.
And just for the record, Your Honor, I personally have seen Ms. Holmes in the flesh or spoken to her twice ever at that deposition and today. Never by phone, never by text. Couldn't distinguish her from a can of paint until she showed up for the depot, and I haven't spoken to her since. So just to let the court know, there is no factual predicate for the
he's saying he never talked to the witness.
An accusation made by the state that the defense sought to take care of her.
And the same for me. I met her at the depot and saw her today.
For the record, it was my first time ever seeing her in my life.
Thank you. All done, guys? Counsel?
Yes.
Yes, madam?
Judge, with regards to that, the statements that were in the records are what was used as impeachment, where it says they said that they were going to take care of us. It was never said the defense team in any way, shape, or form. So defense implied or read into that in some additional context that was not intended in any way, shape, or form. I was basing it on based in the records and the statements that this witness made and put forth in her Instagram account about this case on that. And it's very, in terms of the forming the questions, Your Honor, it was understood that I was put under very strict and difficult conditions to formulate any question because defense obviously wants to limit, because they know the contents of what this individual has said and all of the statements that she has made that are damaging to their client. Hence why the state would be seeking to use her as a witness.
That means nothing, Your Honor. The fact that it's damaging, I'll concede that. It's inadmissible. And the status of this impression that there is a catch-all, we're only trying to seek justice and do good exception to all the rules of evidence. And there is no such thing. If it's admissible, admit it through an admissible procedure. You don't try and end around the court's order and the case law by coming in on some pretext and doing exactly what I told the court would happen and create an entire prejudicial fiasco and introduce inadmissible evidence into the record. That's what occurred, and this jury has been irreparably prejudiced. Or Mr. Demon's interests have been irreparably prejudiced before this jury.
Oh, man. I ain't gonna lie, y'all, this is a tough one, but like, what are the prosecutors trying to do? Because at this point, they are going long. Like, y'all going super long. I'm talking about 2 football fields. Now, what got me is that the judge say, don't do this, and prosecutors went right over there and did exactly what, and then soon they was like, objection. Oh, she switched it up real quick. She just wanted to get it out so the judge could hear. So I could understand why they feel like, damn, now you're causing them to automatically feel some way about Melly. And that's actually what's kind of going on. Melly's lawyers are up to something, and I think it's something we might need a little bit of milk for. You feel me? So for those of y'all in the comments that see me state what we're actually seeing with our own 2 eyes and still sitting up under there, oh no, I ain't going for it, this and that, woo. But I guess it's way too much for me to speak on right now. Y'all let me know how y'all feel in the comments below. Do y'all feel like the lawyer got proper grounds to get a mistrial? Meaning, do y'all think it's gonna be a mistrial, or do y'all think, nah, tough luck, Melly is still screwed? Let me know in the comments.